Looks like everyone is ready. We are now ready for the oral argument in the case of Burton versus West Bend Mutual Insurance. And Mr. Conklin, you may begin.
Madam Chief Justice, and may it please the court. Counsel. Your Honors, specialized testing requires specialized protections. My name is Rob Conklin, and along with Elizabeth Boyer, I stand before you representing Jasenia Burton and her family. It's an honor to be here. We ask this court to overturn the District Court of Polk County's ruling compelling disclosure of protected neuropsychological material against Iowa law, against the plain directive of Iowa Code 228.9. We ask this court instead to take a plain language reading of Iowa Code 228.9 because that best matches the legislature's intent in passing it and also best harmonizes with the rules of civil procedure and the ability of litigants to try their cases. Your Honors, Jasenia Burton was 14 years old driving a Street Smarts driver's education car when a negligent driver ran a red light and crashed into her. It sent her car careening through a parking lot into a pole, and that started several years of care and treatment that culminated in a traumatic brain injury diagnosis at the University of Iowa hospitals and clinics. That was done through sensitive neuropsychological testing, the type of testing this court ratified back in 1994 in a case of Hutchison v. American Family. That court decided that there was, quote, ample evidence to indicate that neuropsychologists could diagnose, discuss, and provide causation opinions for brain injuries just like the one Jasenia had. Iowa Code 228.9 was passed that same year in 1994, and it provided specialized protections for the specialized psychological testing that had become commonplace by that point and only grows today. These tests are different than what you might expect from most medical testing. Often medical testing will be like an X-ray, something that is visual or can be seen. But this testing is no less objective, it is no less useful, but it is a little bit different because it deals with psychological issues. And in neuropsychological testing, often a battery of 30 or 40 small tests will be provided. The results of those tests, whether they come in at above, at, or below average in different areas, can then present a bit of an array. And a trained neuropsychologist can look at that array and see that the constellation of places where there are deficits matches neatly with, say, a ventromedial prefrontal cortex injury. Those tests, though, are highly sensitive and they're a little bit different because they're validated. They're pen and paper type testing for the most part, but they require a naive population that comes in without knowing the test.
How would this play out at trial? Let's assume how do you pronounce it? Tranel. How would a lawyer be able to examine the conclusions that Dr. Tranel drew from the tests without seeing the data? And obviously we don't know how these are scored, but as my understanding, there are interpretive protocols and kind of scoring mechanisms. How would a lawyer be able to test that at trial without seeing the exam and the results?
That lawyers have been doing it for the last 30 years since Hutchison and since 228.9 was on the books by attacking the places where we would normally attack, whether it was the right test for the job, whether that interpolative portion was done correctly by using a licensed psychologist of their choosing to examine the data, and by attacking not the test questions, because remember, Your Honor, when we're cross-examining a doctor, we're not cross-examining the test questions, we're cross-examining the test, whether it was done correctly, applied correctly, or has the utility claimed, and that information is widely disseminated and freely available. As part of the peer review process, these tests are examined and placed into the public purview to show and validate that they do say what they mean and mean what they say, that they do what they purport to do. In fact, some of these tests haven't had the same validation in the front.
Of a competing psychologist, how would that be done? So let's just assume Dr. Tranel looked at some of the answers on there and just misscored them, misinterpreted them. How would a lawyer be able to determine that without actually seeing the materials?
So I'll give an example of when I did it in cross-examination. I represent a man named Brian Mackin, who was given a defense neuropsychological exam that claimed he was malingering on part of his test. I never saw the test results. I never got any of the data or information, but we did receive scalar responses, percentiles and things like that. He was given what's called the Minnesota Multiphasic Personality Inventory, the MMPI, and one of those scales, I believe the FBS scale, is a measure of self-virtue, and he showed elevated self-virtue, which is a sign of malingering under the normal array. But because I could look at the validation protocols for how this had been made, it was shown that that virtue scale was not applied in cases where the person actually was highly virtuous, where they were a clergyman or a peace officer. Brian Mackin was a police officer, so his virtue scale shouldn't have been applied in this way, and we were able to cross-examine him based on that, which is widely and freely available information that didn't require the score itself. Again, not crossing the test questions, but the test itself, the utility and the application of it. And so in those ways, the attorney has to use the same tools you would use when cross-examining a doctor looking at an MRI. I don't know anything about MRIs. I would never be able to present an MRI to the court without a doctor to help me out with it. But I can learn enough to be able to know the science or the things behind it. Further, the legislature's told us exactly what the lawyer is to do in these instances in order to check that data. 228.9 has one exception built into it, and that's that the data may go licensed psychologist to licensed psychologist. The state of play in my 10 years of doing this case has always been that I would get my own licensed psychologist to review the data to make sure that the numbers on the page were indeed the things that they said they were, and that arraying that we talked about, just as Your Honor noted, would be the pinch point or the difficulty point, the friction, that it was applied correctly, and that would give me aid and assistance on doing it. And so the law gives us that exact licensed to licensed professional out, so to speak. That's important because, of course, disclosure is the rule or the goal of discovery, and West Bend raised that in their briefing in this case. But 228.9 neatly harmonizes with the goals and the rules of discovery, because Rule 1500 and 1508, although they militate towards discovery, don't really tell us how. They tell us as a general rule that's what we want to happen, but 228.9 for this highly specialized testing gives us the how. How do we meet that disclosure? We do it by providing it to the defendant, or in this case, it can be either litigant. In fact, usually it's the defendants that are getting the testing done, but either party will get it to their agent, their selected and retained expert.
Wrong in saying the evidence should be admissible. I'm very uncomfortable with this concept of secret evidence that the two doctors get to trade back and forth and the lawyers don't get to see it all. As I look at the statute, there's nothing that says that it has to be admitted in court. I mean, we can protect the confidentiality of these records and just say, just don't use them in court and don't give them to an expert. Maybe we went wrong.
I understand that concern, but I think that casting it as secret evidence puts a little bit of the cart before the horse, Your Honor. And with respect, the issue here is that the science itself is relatively undisputed. The application of it can be. The secrecy is more security. And courts around the country, including the United States Supreme Court in Detroit Edison in '79, have told us that the security is something that is worthwhile and worth keeping. Also remember, the vast majority of neuropsychological testing is not in a litigation environment. It happens in a clinical environment for folks that have strokes or have birth-related brain injuries, things of that sort. Well, they'll never see a courtroom. So the legislature struck this balance, saying that we want this testing to be utilized, but we also want to protect it. So instead of casting it as secret, this is really the way that we're trying to meet all the different masters the legislature has to meet.
I have, which is, I'm looking at pages 8 and 9 of Dr. Trennell's report, which was submitted to the court, and there's discussions of various scores on various tests, various percentiles and things like that. Now, how is it that that's permitted under the statute, but it's not permitted to actually look at the raw, for the other side to actually look at the insurance company to get the raw scores?
Rationale behind that is right in 228.9 itself, which specifically talks about the test materials, but also notes that related issues can be disclosed here. Also, if we look at some of the amicus briefing from the IPA, Psychologists themselves in their code of ethics have drawn pretty tight lines here, which, by the way, 228.9 comports pretty well with. It's a strong implementation, but it really does cohere. The idea here is that
expert disclose whatever the expert wants with the party's lawyer? Or are there subjects that are off limits even there?
they cannot. In fact, if we look at 228.9, it specifically says it can't go to the person who took the test at all. And as her agent, I certainly would fall within there. Dr. Trennell has not shared the raw data or the test materials with me in this case. And in fact, no neuropsychologist I've ever worked with has. So the playing field is level in that sense. The idea here is that the main threat is that if these tests become widely disseminated, folks who take the test can learn the test. And they can learn to do better or they can learn to do worse. It's not like an x-ray where if you get several x-rays, your bone doesn't get, you can't fake a broken bone because you took more x-rays. But here, there are widely described practice effects, meaning you can practice and come to a predetermined outcome. That's why the naivete of the test taker is part of the validation process, meaning that the tests only do what they say they do, what they're proven to do objectively when you don't have a multiple shots at it.
Mansfield's question about Dr. Trennell disclosing some of the test results, or at least the percentiles. You said the statute is drawn in such a way that it allows that distinction to be made. What language are you referring to in 228.9?
At 229, it states that shall not disclose the test material to any other person. The test material shall not be disclosed in any administrative, judicial, or legislative proceeding. That means that the materials, which are scoring guidelines, things like that, are strictly off limits. And then it says, upon the request of the individual, all records associated with the psychological test to that individual. And we understand that from looking at some of the administrative code provisions, that they're generally talking about things that have personally identifying information for the patient or for the testee. And here, that I don't think the percentile scores reach that. Multiple people could have the same percentile scores. Of course, there's identifying being done here. Unfortunately, I think that's a question better left for the psychologists, but it does appear to be standard, at least through the amicus briefing we've received, for the scalar numbers to be okay, but the raw data itself to be the bridge too far, to be the step too far. Now, that data can go between the licensed psychologists to verify that it is within that percentile, that the expert is not on a lark or on a limb. And we have had cases where we found simple addition errors, where the 37th percentile required 17 points, but it actually added up to 19 points. And so they did the math wrong, and they had to go back, and the other side had to fix or change their report to reflect that. So it does do the things that it needs to do to give everybody a fighting chance, while also ensuring that this information stays secure. Again,
if the only issue is checking the math to make sure the percentages are accurate, you mean the insurance company has to hire a neuropsychologist just for that purpose?
The only issue, Your Honor, but that is probably the first step. The issue here is that there are the raw data, the raw scores, then are essentially, as I understand it, placed into an array, meaning that they're interpreted based against, or set against norms for each individual test, and also against the person's personal background and normative objective statistics.
A protective order insufficient to accomplish competing objectives of allowing full discovery, but also not disseminating the test materials and test data?
Put, a protective order is the wrong tool for the job. It's a powerful tool, but here, as the Supreme Court found in Detroit Edison, it has two real problems. First, it can lack reach because it only applies to parties. And second, it doesn't really account for the real problem of inadvertent disclosure. Something that's an accident isn't really going to be punished. The district court also is put under a lot of pressure to do something they're not really equipped to do because this is highly sensitive stuff. We have trouble even parsing it out here among this body with far more resources available to it.
Attorney's eyes only. So you have the psychologist and the attorneys. They could look at it. And then the exhibit didn't have to be displayed at trial, but at least everybody had a chance to look at the materials.
The answer is that the legislature had the opportunity to do that. In fact, other parts of the legislative code do say subject to a protective order except as allowed by the district court. They had that technology in 1994 and chose not to use it. They made it like,
Though, where a lawyer doesn't get to know all of the info that their expert has? I'm trying to think of any other kind of limiter like this.
the tort context, Your Honor, but that is part and parcel of the specialized nature of this testing. It's just a different animal. I see I'm out of time.
Address Iowa Rule of Evidence 5.705 that if the expert testifies, they can give an opinion without disclosing the underlying facts or data, but the expert may be required to disclose those facts or data on cross-examination.
Permissive may in that instance is exactly where since 228.9 is phrased as a shall, it is a duty imposed upon the psychologist or neuropsychologist, then the district court in doing its balancing would have to compare that to the need for the underlying data. And here, I think that permissive may would be subject to the rote prohibition provided by the legislature elsewhere. Thank you so much.
Thank you, Your Honor. May it please the court, counsel, Adam Ziener for the appellee. What the court, notwithstanding the good questions that have been discussed, what the court has not discussed with the appellant is that there are voluntary disclosures under 228, and there are compelled disclosures under 228, right? Compelled disclosures, 228.6, and we have this rubric. Voluntary disclosures, compelled disclosures. Why do we have that distinction? Well, we have that distinction throughout the law. Our district courts are well qualified to, one, measure scope and sufficiency of privilege claims, whether statutory or common law. Why? Because plaintiff here, even though, to me, under oath, has declined any cognitive issues from her low-speed car accident, even though to Dr. Trinnell, which the court has, not under oath, her hired expert, not a treater, her hired expert, she says to Dr. Trinnell in an interview, do you have any cognitive delay? Any cognitive challenges? No. And yet, what do we have? What we have here now is Dr. Trinnell saying, got all that, but I come to the determination 4.5 years later, there's some mild cognitive deficits. 1. 2, oh, by the way, it was caused by this low-speed car accident 4.5 years ago, for which there was no substantial or meaningful treatment other than the x-rays, nothing, unremarkable, other than the MRI, nothing, unremarkable, other than she's treated and released within 2 hours. Under oath to me at the deposition, she says, you know what, Mr. Ziener, I have 2 complaints. I've got headaches still. And you know what else? I also have some anxiety while I'm driving. She also acknowledges, well, I do have this family history of headaches. My mom has migraines. Yeah, I had headaches before. The jury will sort that out. Her other complaint, I've got this anxiety while I'm driving. Of course, she was driving 2 years later, 2 years before Dr. Trinnell took a look at her. She was in another car accident for which Dr. Trinnell gives no account, says no problem causation there. I'm going to relate causation back to the prior car accident. Now, to the court's good question, these are some of the challenges within a case like this where plaintiff is suing for money damages. Of course, from her tortfeasor, she's recovered. She now is suing us, wants more money by way of her recovery. Of course, she was treated and released. Thank goodness. good recovery.
You're doing a good job of persuading me you can defend this case without the information. So tell me, how do we get around this language in the statute that says, except as otherwise provided in this section, you don't get access to the psychological test material?
Very straightforward, Your Honor. That's a voluntary disclosure under 228.9. If a plaintiff is going to put his or her mental health in issue, which is what 228.6 4A directly confronts, then this material becomes discoverable, not profound. Also, Your Honor, to your good question, how do we know that this is the rubric? How do we know that this is the right answer? How do we know that the court could just get to 228.6 and go no further because that's the plain language of the statute? Well, we know because the legislature, if we care to look, of course, I'm familiar with the, just by happenstance, but with the peer review statute, right? Peer review, confidential, not subject to discovery, subpoena, or other means of legal compulsion. Peer review, that is sacrosanct. Now, courts still monitor the scope and breadth of that privilege, but it's a privilege, and it also, within the text of the statute, says we aren't going to allow legal compulsion. That's not the only place. We have 3 other statutes within the medical context. 135P.2C also says not subject to discovery, subpoena, or other means of legal compulsion. Of course, that is what appellant's position is here. They don't like that these records were compelled by the district court, and that's what happened. Of course, we, the legislature, the courts, if this is going to be put in issue, of course, not just do the lawyers want it, the courts. The court asked a question, well, 228.9, no one has acknowledged 228.9, that doesn't allow those materials to go to counsel, to go to the court, to go to the jury. Someone might imagine a situation where, let's say, well, one, why would we ever have a scenario in that regard? We can't under our statutory rubric. But we would never have the court not have access to these records to decide issues, dauber, admissibility, what have you. The counsel and the fact finder. Of course, we have a protective order in this case before this court granted interlocutory appeal where the other side said, yeah, no problem. Zener, you can get them. The court can get them. The only folks they didn't want to get them were the jury. But why is that absurd? Why is that an absurd result that this court should not sanction? Because one could see a scenario where we have expert A say, yep, on these same facts, she has mild cognitive deficits. A competing expert may say, yep, on these facts, no cognitive deficit. How is that helpful to a jury? In what world would we give a jury that? Our system is based on the fact that we are able to, 1, are entitled to every man's evidence. 2, test that evidence by way of cross-examination. And 3, ultimately to a jury, 100.12, it's your uniform jury instruction regarding whether a jury ought to consider and what weight the jury ought to put on an expert. What you have here is, I'm an expert, trust me, that gets to a jury.
You still haven't quite addressed Justice Mansfield's argument about, you can say we don't do that in our process, except that the legislature here says, except as otherwise provided in this section, test material shall not be disclosed. Opposing counsel said that the test material reference is a narrow set of information. Can you address what kind, and I think you suggested in your brief that they were trying to protect information that went beyond test material. Could you address what specifically the statute does apply to the extent that it does apply?
Thank you, Justice. In response to your and Justice Mansfield's question, 228.9 just doesn't say what appellants want it to say. If 229 or 228.9 said these materials are not subject to discovery, subpoena, or other means of legal compulsion, as the legislature has laid out in 6 other statutes.
There are ways that they could say it, but it does say shall not be disclosed in any judicial proceeding.
Again, Your Honor, 228.9 is a voluntary disclosure. It's responding to point 3, which is another voluntary disclosure for a person, just an individual. Says nothing about lawsuits or otherwise. 228.3 says this is how you get your records. 228.9 comes along and says, except for these records, on a voluntary disclosure basis. But when someone puts their mental health in issue, particularly here, a paid expert, these are subject to legal compulsion, which is exactly what happened here.
Ask you this. As I read 228.9, it says, the test material shall not be disclosed in any administrative, judicial, or legislative proceeding. I think there's some tension between that and saying that it's only handling voluntary disclosure. I mean, it seems like a blanket prohibition on disclosure in a judicial proceeding, which, as you know, would often be involuntary, compelled.
Could be under the statute. What I'm reading from is one of the statutes where the legislature knows how to say, we will not allow this to be compelled. And here's why this is important. 135P2, it uses both phrases, right? It says, shall not be disclosed in any judicial, administrative, or arbitration proceeding, and will not be subject to discovery, subpoena, or other means of legal compulsion. This statute, 135P2, that they use both phrases, underscores our position.
Administrative regulations and what impact, if any, they have in this case? Because those seem to be a little bit broader than the statute even.
The administrative regulations they are silent as to compelled disclosure, number one. They don't say anything relative to compelled disclosure. Number two, the administrative regulations do discern, Justice, between test materials and test data. That distinction does not make a difference. You are in Auer and Chevron deference is dead. You need not defer to the agency. You don't have those definitions under 228.1. You need not go there. But that is, in response to your question, what you have is 228.6.4, where this court has decided I think it was Justice Waterman who wrote for the court in 2014 in In Re AM, you need not get that far. You can say, look, 228.6 says this is plain language. Is she 18 or older? Did she put mental health in issue?
481.888.4 sub 3 specifically says a licensee shall not disclose test materials in any administrative, judicial, or legislative proceeding it seems clear, at least from the licensee's perspective, that just can't happen under these regs. Let's assume 228.6, the kind of putting it at issue, doesn't exist. Is there anything in these regs or statutes that would allow discovery as you're advocating for?
Your Honor, anytime there is no privilege, statutory or common law, even our most sacrosanct privileges are subject to exception, and courts can compel exceptions and winnow or enlarge or graph the scope of those privileges. And so, to the court's point, and what I believe to be the court's point, there is nothing relative. Yes, there is a privilege. It is a statutory privilege. That notion is, of course, not profound. There are statutory privileges regarding medical records, generally, right? Those get waived when, or we allow exception to those when someone is in a lawsuit, right?
These provisions together and try to harmonize them, and 228.6, generally, if you put your mental condition at issue, it becomes discoverable. But then we have the more specific statute about these test materials that begins, except as otherwise provided in this section, meaning 228.9. And I think that trumps the more general provisions, doesn't it?
Justice, for the question. No, in answer to your question, and here's why. The court's case in In Re AM, if you needed to reach that, your decision in Re AM acknowledges there it was a China case, but the issue there was, wait a minute, which is the more specific statute? And I think, Justice, you held on behalf of a unanimous court that the litigated position or the litigated statute was actually, and folks want to say more specific, I've seen it more specific, it's certainly the special statute, which is more special than the...
Involves this special psychological testing materials. It was just, could the therapist be compelled to testify, right? So now we have this test materials. Could you speak to the amicus brief by the Iowa Psychological Association about all the consequences if these test materials get out into the public domain, that the tests will lose their validity and there'll be enormous social costs resulting? And why hasn't the legislature balanced these competing concerns in the plain language of 228.9?
To the extent that's a gripe, it's not for this court to rewrite, number one. Number two, again, the legislature knows how to write if it wants to protect certain items from compelled disclosure. The legislature didn't here. That's not for this court to rewrite, nor will, again, and this court has a good quote regarding if there is a gripe, they ought to go to the legislature. But to your point about competing interests, or the issue of competing interests, the interests of full and fair disclosure, the interests of this one statute turning on its head the way we litigate cases without the express where we list in 6 at least other places protecting it from compelled disclosure, and without point 6's heading, which is compelled disclosures, this is a public interest that is quelled by what Judge Hanson did in indicating a protective order. And on those competing interests, we ought to have courts full and fair disclosure, entitled to every man's evidence, particularly when you are hired, as Dr. Turnell was here, as a hired gun, puts himself and subjects himself to this court's rules and rules of disclosure, that he's opting in and then wants to be a sword and a shield. I see my time is up.
Thank you.
Thank you, Your Honor, and may it please the court. Hopefully the masterful cross-examination we just saw of the facts of this case assuages some of the court's concerns here. There's one other important thing to point out, just as a housekeeping issue. The disclosures in 228.6, particularly in sub 4A, even there it says mental health information may be disclosed. It's permissive. It is not required. It's subject to everything else it may have.
Those that are protected by 228.9, this are included within the definition of mental health information?
The tighter subset, which is why 228.9 must control under Iowa Code 4.7, where the special or the specific controls over the general. We can see this because 228.9 was added 8 years after the remainder of Chapter 228 to give further emphasis on that more specific, narrower part of the funnel. So under the rules of statutory construction we would use, then it's pretty clear that that becomes the specific provision that controls over the general. And in fact, the district court even hinted at this by calling the 228.6 provisions the broad provision, even as using it as a reason to compel, which is one of the errors at law that they made in this case. There are some concerns about protective orders that have been raised, and why can't this be attorney's eyes only? We know this through amicus, that attorneys don't have the same ethical considerations, the same legal considerations that exist for these other parties. And we also don't have the same specialized training, meaning that I may not know why something is important or what's important. And certainly the APA wouldn't have the ability to go after my license in the same way the bar would. So we're not meeting those things that are part of why 228.9 was passed, which we see right in the legislative history. 228.9, the legislature told us why they passed it. And it's exactly what Justice Waterman hit on, that the downside risk for societal harm is very broad here. It's far bigger than the litigation context, because once these are out in the open, once they become invalid tests, they can't be used by anybody, not just by litigants. And so while there's some pain points here for sure, while it's unorthodox because the usual medical technologies that we use don't have that same downside risk of harm. They don't have that immense social pressure, and this court's purview is generally to take the long view on these topics. Now, maybe there needs to be legislation that looks at how this happens, but that's an issue for the legislature. And in fact, there have been bills in
This discussion, you're kind of presupposing there's a right just to put the evidence on, right?
Certainly, Your Honor.
Just isn't such a right. That if you have a witness who's able to conduct examinations and the examinations themselves can't be disclosed to the lawyers and the data from the examinations can't be disclosed to the lawyers and there can't be effective cross-examination, then maybe the witness just isn't allowed. And that protects the purpose of the statute, which is to protect the integrity of the testing instruments. But you just got to find other evidence. Why can't that be a solution?
Were the case that all those things you listed were true, Your Honor, then maybe that would be a worthwhile tack to take. But the underlying premises just simply aren't correct. There is adequate cross-examination available in these instances. There's adequate evidence of what is and isn't appropriate in the forensic context. And we have an easy directive from the legislature on the way that this can get into the hands of not the parties themselves, but their agents, so that we can have proper protocols followed. So while it's not the way that West Bend would prefer to receive this information, it is available to them. And in fact,
What about, there's some discussion in the briefs about a distinction between test materials and test data. So like I give my Drake students nowadays, since AI, I do a multiple choice final exam. And I get a score sheet which shows how every student answered all the questions. Now, I wouldn't want those multiple choice questions out in the real world because, truth be told, I reuse some of them from year to year. So Mr. Wolf is laughing. He took the test. But I wouldn't have any problem with the raw score sheet, so that if you wanted to see if actually the score that I'm talking about, the grade that I assigned to a student is correct based on their raw score. Is there such a distinction available here?
no doubt that under the administrative code and the applicable portions of ethics codes, they are defined differently, test material and test data, but it's not a neat side-by-side. Test data subsumes some portion of test materials because of the specialized nature of the testing. On some of these tests, the test material, the test itself, is written on with the answer. And so at least for some of these tests, you cannot meaningfully separate them. There's no way. And in fact, Your Honor, I see my time has expired, if I may briefly conclude. When the APA does its definition, it does say that test scoring includes those portions of the test materials that are so tightly intertwined or have that information written directly on them. So they do, the Venn diagram isn't a total overlap, but it does overlap, making it a distinction without a difference for purposes of the court. Further here,
Right on that distinction. So let's assume that we think there's a statutory distinction between test materials and test data. And from the examples in the briefs, we know that some of them, the test material and the data are the same thing. What if they're not, and it's just a bubble sheet? How do we draw that distinction with the statute and the reg? And then how is that distinction brought to the attention of the court if you're saying the statute prevents disclosure even to the judge?
I think we'd be relying on the ethical principles that are already enshrined in the Iowa Code of Ethics for Psychologists, as well as the national ones, that we'd be getting the truth before the court through affidavits, just like with anything else that the district court may not have a background in. In that instance, then, it may be completely acceptable under 228.9. It wouldn't violate the plain text to provide those materials, except the utility of it's so low. To get the bubble sheet like Justice Mansfield gave his students, what do we do with that? What's that even help? And so we're really creating a circumstance where, and there still is risk of inadvertent disclosure there too, Your Honor, where if I know a certain percentile fails and I have the answers that fail, I could potentially reverse engineer a failing grade off of those too. So if those were to leak into the public purview, just as was the concern for Detroit Edison in 1979, even more so with the internet, we still have that risk of disclosure problem while having almost no utility to litigants. Thank you so much.
Burton versus West Bend Mutual Insurance Company is hereby submitted, and the court is adjourned for the day.